before the lunch adjournment, we've just finished with the proposition that the requirement to respect the sovereign equality of states is exhausted by the Foreign Act of State doctrine in its guise as a rule of conflicts law, and by state immunity, where the notion of exercising a state's jurisdiction is a restricted notion, meaning that the state must assert its sovereign authority by purporting to impose its laws on a foreign state.
It's not really a very conventional conflict of laws point. It's a point I made yesterday. Is it because it doesn't actually refer the adjudication of the dispute to another law. It says regardless of what the law in the foreign country is, because this is a sovereign act, we will give effect to it.
Yes, so one applies the laws of the foreign
state. No, you
state.
don't, because even if it's unlawful, Princess Paleolga, you give effect to it. So it's not just a conventional conflicts of law point.
Yes, Mr. Herman's going to come to that case, but in our submission it wasn't unlawful there. It was, so if one had a situation, where the Executive Act, for example, was governed by the law of the foreign state, you would apply the law of the foreign state.
Well, I got your submission, and I was suggesting that wasn't it, and we can look at Princess Paleolga. Yeah.
Just before I come on to summarising our case on state immunity, there's just one point to make. It's important to keep in mind that state immunity is not, in a sense, a single doctrine. That is, that once a sovereign state loses its immunity, it loses its immunity for all purposes. There is a distinction between the immunity of the state for the purposes of adjudication and the immunity of the state for the purposes of enforcement. And at the moment, where a state, in terms of the development of international law, at the moment, where a state loses its immunity for the purposes of adjudication, the court can go on and adjudicate and make whatever orders it makes as a result of that adjudication, be that the payment of compensation and so forth. But the enforcement of those measures is a different question. And there remains a very, very limited basis in international law upon which judgments of courts are enforced. But we are concerned with the state immunity doctrine in relation to its application to the adjudication by the court. And finally, just before I come on to summarise the case, I just wanted to make reference to one of the matters that Mr. Eadie raised yesterday in his opening, which related to the linked cases to Mr. Rahmatullah's case. And he mentioned that there are a number of cases, he put it in the thousands of cases arising in the context of the aftermath of the Iraq War. And in case he left the impression that, firstly, there are thousands of such cases where compensation is being claimed, that isn't correct. There are certainly many hundreds of such cases, but many have been settled already. And secondly, insofar as you were left with the impression that they are all transfer cases, as opposed to cases where the claim is in respect exclusively of the acts of the United Kingdom because of the activities of its armed forces in directly detaining or injuring individuals, I'd like to correct any misapprehension your lordships and my lady might have about that. There are not thousands of such cases. We don't entirely know yet the final number because there's a new tranche of cases. But so far, I believe the number we have positively identified is 10, but there may be up to a couple of hundred of such cases where, and the reason those cases arise is because there's one particular detention facility called Camp Booker where control passed between the United Kingdom and the United States in relation to the same camp, which is what creates the complexity. But the number of cases of a positive transfer, such as Mr. Rahmatullah's, are very small in number, where there was a transfer into the physical custody of the United States who then held him in somewhere like Abu Ghraib or rendered him off to Afghanistan. So, to summarise our case on state immunity, the appellants not only can offer no coherent foundation for the radical interpretation that they urge upon this court in relation to state immunity, but, as we will show, that interpretation marks an equally radical departure from the common law, from the clear terms of the 1978 Act, from customary international law, and equally it is unsupported by the supposedly analogous area of the jurisdiction exercised by the ICJ in relation to determinations brought before that court. And at the heart of this issue, as I've already touched upon, at the heart of this issue is the question of what is meant by subjecting a state to the jurisdiction of another state's judicial machinery. Or, to put it another way, what is meant by impleading? That's the critical question. Mr. Phillips sought to focus the court's attention upon the interests that might be affected and how broad those could be. But actually, if those interests are not affected by being impleaded within the proceedings, it doesn't matter. State immunity doesn't catch them. So it's that concept that we need to look for in the case law. What is meant by impleading? I'm going to come to the common law cases first, if I might, because they all preceded the introduction of the 1978 Act, and then they informed, understandably, the way in which the 1978 Act is then read. In summary, these cases show, firstly, that before the 1978 Act was introduced, the English courts were applying their understanding of public international law on state immunity. They identified the immunity that states enjoyed as involving two distinct elements. Firstly, an immunity in the person of the state, but secondly, an immunity in respect of state property. And those both went towards what encompasses state immunity. When we look at the cases, we can see different judges making decisions on different bases in relation to all these property cases. Some of the judges look at them and look at the issues and determine that this is a case of direct impleading, because what is impleaded is the property of the state on proper analysis. And given that the state's property is immune, that is a direct claim against the state's property, and therefore that is immune. Other judges look at it from a more indirect angle by focusing on the person of the state and saying, well, this is the state's property, and therefore, by bringing this claim which seeks to assert legal control over that property, you are in fact indirectly impleading the state, because you are interfering with the enjoyment of the state, by the state, of its possession or interest in that property. The critical point is, it doesn't make any difference which way the court analyses it, because you've reached the same conclusion, because indirectly impleading the state is exactly the same as directly impleading its property, because the concept of impleading requires that the court asserts its judicial authority over the subject matter of the claim. That is, it determines legal rights, interests, obligations, and so forth in respect of the subject matter of the claim. That's why it doesn't matter what route ultimately the court takes, the outcome is the same. So if we can turn to volume 9 and to first tab 75, page 4631, and the Parliament Belge case. So in this case, a Belgian state-owned mail boat collided with the plaintiff's ship in Dover Harbour, and the plaintiff brought proceedings in rem, therefore against the vessel, seeking to cover redress in respect of the collision. And if the court can turn to page 203, this is summarised by Lord Justice Brett, 4637.
4637.
4637.
Thank you.
We can then see a summary of those facts. And then at the bottom of 4637, in answer, it was averred on affidavits which were not contradicted that the packet boat, besides carrying letters, carried merchandise and passengers and their luggage for hire. So we see a little introduction of questions about commercial use, which in the end didn't form part of the decision. The question that the court then posed is at the top of 4638, that top paragraph, three main questions were argued, and the first is whether, irrespective of the express exemption contained in Article 6 of the Convention, the court had jurisdiction to seize the Belgian vessel in a suit in rem. And the three questions are then distilled by the court into the first and third, or rather the court decides it'll answer the first and third, because that will probably mean it doesn't have to answer the second. And if one moves down to the paragraph starting, the proposition raised by the first question seems to be as follows: has the Admiralty Division jurisdiction in respect of a collision to proceed in rem against, and in case of non-appearance or omission to find bail, to seize and sell a ship present in this country, which ship is at the time of the proceedings property of a foreign sovereign, is in his possession, control and employ as sovereign by means of his commissioned officers, and is a public vessel of his state, and so forth. If the court can then turn to page 205, and that first, the second paragraph on the page, starting halfway down, the first question really raises this: whether every part of the public property of every sovereign authority in use for national purposes is not as much exempt from the jurisdiction of every court as is the person of every sovereign. And what then follows is an analysis of the immunity of the sovereign, and the court reads the rest of that paragraph on 4639 and then down to 4640.
Where do you want to read you on 4640?
Really the entirety of the page. There are two passages in particular I will just pick out for your lordships. Halfway down the first major paragraph, about 6 lines down, for all jurisdiction implies superiority of power. Authority to try would be vain and idle without an authority to redress, and the sentence of a court would be contemptible unless the court had power to command the execution of it. But who shall command the king? And this was taken from Blackstone. And then at the bottom of the page, about 6 lines from the bottom, the court says this: a foreign sovereign is not understood as intending to subject himself to a jurisdiction incompatible with his dignity and the dignity of his nation. By dignity is obviously here meant his independence of any superior authority. So again, we get the notion here that what one is concerned with in protecting the value of sovereign equality is that you don't assert your authority, your power and control. And the conclusion that the court drew from looking at these authorities, the authorities it considered, is set out at the bottom of page 207, the bottom paragraph, and this is in relation to the sovereignty of the state and the state's immunity. So if the court could read that last paragraph to the top of page 4642, the next page.
Thank you.
Then, in the immediately following paragraph, we can see that the court turns its attention to property, looks first at ships of war. So the reason of the exemption of ships of war and some other ships must next be considered, and the first case to be considered is the exchange. And the court then goes on in the following pages to look at a number of cases in relation to ships as an aspect of the property of the state. And at page 4648, at the bottom, with paragraph starting at the very bottom of the page, the principle to be deduced from all these cases, and we can see that exactly the same basis as has been found for conferring immunity on the sovereign is found for conferring immunity on the property of the sovereign.
Exactly.
Sorry, where's the...
That's 4648 at the very bottom, the bottom
Principle
paragraph.
to be deduced. Yep.
Then goes on in the next page and a half to consider some authority which is said to be inconsistent with that. And at page 4651, halfway down the page, states in a sentence starting at the end of the line, having carefully considered the case of the Charkey, the court maintains the conclusion it had reached on the early decisions, i.e. found that there is no inconsistency.
Yep.
And then we have a discussion of direct and indirect in pleading. So they say, so the court holds firstly that this proposition would determine the first question. So the fact that the state's property is immune determines the first question in this case. Answer, obviously, the immunity claim must succeed. And then the court goes on to consider indirect in pleading in the next paragraph. And if the court could just read that next paragraph on 4651.
This proposition, yes.
This proposition would determine the first question. But we cannot allow it to be supposed that, in our opinion, the owner of the property is not indirectly impleaded. So we're now looking from the property, which is immune in its own right, to the person to whom the property belongs. And if one then goes to the next page, 4652, halfway down the page, we have a consideration of the basis upon which, in a claim such as this in rem, following a collision, the person who is the owner of the property becomes impleaded. And that starts at a sentence halfway down the page where the last word on the line is in a claim made in respect of a collision. If the court could read the next 10 lines or so.
Yes.
So even though that's the state's property, it's not automatically the state itself impleaded unless these conditions are fulfilled. That is, that the ship was under the control of its agents or servants at the time. But the consequence is spelled out at 4653 at the top as to why it becomes impleaded in those circumstances. And if the court could read all the way down to the end of that paragraph.
What all this amounts to is actually an action in rem is a direct impleading. I mean, that's the reality of it. The real distinction is between personal and subject matter immunity, and this is clearly personal, if it's anything at all.
Well, in my submission, this shows that it doesn't necessarily follow that it's a personal pleading, because it is only a pleading against the state itself if, in fact, the ship was under the control of state agents at the time. If it wasn't under the control of state agents, then liability would not arise to make recompense through the ship itself. The consequence, therefore, being that it's an indirect impleading, which is dependent upon circumstances being met in respect of the state's agents. So there are two distinctions. Its property is directly impleaded, and because there is a basis, a separate basis for state immunity in the state's property, that's a direct impleading. But this is actually an indirect impleading.
If the ship was bareboat chartered, so it was being operated by someone else, then under the doctrine which at this stage prevailed of absolute immunity, what would the position have been?
Well, according to this, the state would be directly impleaded because it is its property. It remains the state's property.
Although he's not operating it, and wouldn't be liable, therefore, for the
No, but
the
analysis that has gone before and that has disposed of the first issue is an analysis which looks, as a matter of public international law, at what state immunity comprises. Two elements. One, immunity of the state, ratione personae. Secondly, immunity of the state's property. Those are the two elements that, bundled up together, make state immunity. Then there is the separate analysis which puts aside the property immunity and says, well, let's look at this through the prism of the state as a person. And in that analysis, it is only indirectly impleaded if it is in control of the vessel.
Yes.
So in any event, whichever way one analyses this, one reaches the same position, which is that impleading here means that you have to actually make a decision, the court has to make a decision that is decisive of those interests, legally decisive of those interests. That is, the consequence of the decision will be that the sovereign's freedom in respect of its property to do with it as it wishes will be taken away as a consequence of the judgment, or will be adjudged no longer to be a freedom in law. That's the consequence. It's a proper assertion of legal authority. So, turning from there to the Christina, which is at 4475, tab 68 in the same volume. One has to go back.
Sorry, which tab?
That's tab 68. So here, this ship, the Christina, belonged to the Appellants, and the Appellants were a Spanish company. The ship was docked in Cardiff when it was requisitioned by the Spanish government. And the owner of that ship, the Appellant, issued a writ in rem claiming possession of the ship. And there are Lord Atkin's analysis is very often quoted in subsequent cases, but actually Lord Wright says some interesting things as well about the notion. If we turn first to Lord Atkin, 490, page 4480 of the MS, and we have that much quoted statement in the paragraph starting, the second paragraph of his speech, the foundation for the application to set aside a writ is to be found in two propositions of international law which are engrafted into our domestic law, which seem to be well established and to be beyond dispute. The first is that the courts of a country will not implead a foreign sovereign. They will not, by their process, make him, against his will, a party to legal proceedings, whether those proceedings involve process against his person or seek to recover from him specific property or damage. So that is bundling up into one the two elements of state immunity, against the person and against the property. The second is that they will not, by their process, whether the sovereign is a party to the proceedings or not, seize or detain property which is his or of which he is in possession. So that's clearly referring back to the second way in which the matter was decided in the Parlement Belge, the indirect impleading point. So turning then to the speech of Lord Wright at page 501, which is 4491.
Yep.
Bottom of the page. The respondent government does not contend it is the owner of the Christina, but says that it is and was at all material times in de facto possession of the Christina and was therefore, without its consent, impleaded by the writ in rem, claiming possession adversely to its actual interests. And then the very last sentence there, it further contends, this is an alternative argument, that the action involved a claim to interfere with its right of direction and control, coupled with actual possession acquired by reason of the requisition. And then, halfway down that page, Lord Wright says, in my judgment, both contentions are well-founded, and the order of the courts below may be sustained on either ground, but the grounds are separate and call for separate analysis. They both alike are based on the general principles of international law, according to which a sovereign state is held to be immune from the jurisdiction of another sovereign state. This is sometimes said to flow from international comity or courtesy, but may now more properly be regarded as a rule of international law accepted among communities of nations. And if we then move on to page 4493 and the top, the rule is naturally subject to waiver by consent of the sovereign on the second line, who may desire a legal adjudication as to his rights, because that, of course, is the consequence of submitting to the jurisdiction. And then, in the next paragraph, the first of the two rules here relevant, namely that the independent sovereign may not be directly or indirectly impleaded in the courts of this country without its consent, has been recognised as a general proposition in many cases. And the court then goes on to look in detail at some of those cases, including the Parlement Belge, and concludes at page 4494 halfway down, after the quotes from the Parliament Belge, I think the substantial soundness of this ruling is corroborated by considering the nature of the modern writ in rem. So we're talking about indirect impleading here, and he's considering the modern writ in rem. He then goes on to consider that, and at the bottom of the page, 4494, to take the present case, the writ names as defendants the Christina and all persons claiming an interest therein, and claims possession. The writ commands an appearance to be entered, and so forth. A judgment in rem is a judgment against all the world, and if given in favour of the plaintiffs, would conclusively oust the defendants from their possession, which on the facts I have stated, they beyond question de facto enjoy. So a clear consequence of the legal determination which interferes with the sovereign authority of the foreign state to do what it will with that property which is in its possession. Whether it has a legal right to that property or not is irrelevant. It is in possession of it. And here we have the statement again, which is much repeated. They are given the clear alternative of either submitting to the jurisdiction or losing possession. In the words of Lord Justice Brett, the independent sovereign is thus called upon to sacrifice either its property or its independence. And the court goes on to say, few lines down, it may be said that it is indirectly impleaded, but I incline to think it is more correct to say that it's directly impleaded, and that's because the writ actually names all persons who claim an interest in the Christina, and that's a specific reason for finding as a direct impleading. So if we then go to 506 and to the alternative basis, and that is dealt with in the bottom paragraph on page 4496. This ground would by itself, subject to some questions to be considered below, be enough to entitle the respondent to succeed, but there is a second ground on which the writ should, in my judgment, be set aside, which is that it claims to interfere with the property of the foreign sovereign. That the court has in general no jurisdiction to do this is illustrated in the Parliament Belge. And he then goes on at 4497, halfway down the page, to say the rule is not limited to ownership. It applies to cases where the government has a lesser interest, which may not be merely not proprietary, but not even possessory. It's been applied to vessels requisitioned by a government and so forth. So he then goes on to consider the arguments as to why, in the circumstance of this case, there is no immunity, and that is as to whether or not it's a commercial vessel. So we can see again, both direct and indirect impleading are deployed. The third case, which the court was taken to this morning, is again in volume 9. It's back again, tab 66, page 4415.
Yep.
Don't need to look at this in any detail, but the point that was mentioned about it this morning was in respect of the conversion claim. So that the claimant was prepared to step back away from any claim in respect of the property and simply seek a claim in conversion. And the critical point about this, and if we look at the speech of Lord Radcliffe, we can see it clearly at page 4452.
Yeah.
Towards the bottom of the page, subject to the payment of costs and special damages, an action for damages for conversion can always be stayed if the defendant offers to hand over the property in dispute. In that sense, a suit for damages for conversion is an attempt to use the court's process to interfere with the existing possession of the chattel to the title to which is in dispute. If the defendant continues to resist and damages are awarded against him, he may keep the chattel and pay damages. But if he does, he becomes entitled, if he is a bailee, to set up the plaintiff's title to the goods, which he has thus paid for against his own bailier. In other words, the court's judgment in the personal action against him would materially affect the existing right of his bailier in respect of the possession and disposal of the chattel. The result of a judgment in damages is thus some analogy to the sale by the court of a chattel which is in the possession or under the requisition of a foreign sovereign. So there is a direct implication for the legal interests and rights of the state that arises from the legal consequences of a claim in conversion. So it's not a case in which there is no legal implication from the court adjudicating upon the matter in dispute. Next, if we can turn to volume 8, and that's page 4304 in tab 63. Case is Rahim Tula and the Nizam of Hyderabad. So this is a claim, if the court simply reads the very short head note.
Sorry, which tab have we gone to?
I'm sorry, that's 63, page 4304. From there, page 4318, and halfway down the page on 4318 in the speech of Viscount Simons. The first job of the court is to identify in what capacity the appellant accepted a transfer of funds. And there then follows a discussion as to whether or not he was acting as a private individual. That's dismissed out of hand. And then the question is, was he an agent of the state or was he an organ of the state, to be equated with the state? And if the court reads through to halfway down the next page, 4319.
How far into
To
page?
the end of the quote, the Dicey quote.
I see.
It's a quote from Lord Atkins.
Yes.
I'm sorry. I'm so sorry.
Lord Atkins, we've already,
yes, I'm
we've,
sorry.
we've already seen.
No, we've seen that. To the end of the conflict of laws and the reference to Dicey. So what we have here in the top part of the page and the bottom part of 4318 is really a proper description of what indirect impleading is. As soon as it is proved that quoad the subject matter of the action, the defendant is the agent of a sovereign state, that in other words, the interests or property of the state are to be the subject of adjudication, the same result is reached. And then at page 432 at the very, very top, we have this sentence: it has the legal title which cannot be displaced except by litigation, which it is entitled to decline, that is the state. And then 2/3 of the way down the page, sentence starting a suit, the last two words on a line, a suit by a third party, the Nizam, is calculated and intended to interfere with the title of Rahim Tula and his principals, the government of Pakistan, and with their possession or control of their property. It can only be maintained if the government of Pakistan take a course which their sovereign dignity entitles them to reject and descend into the arena. I've used the words possession and control because they are the words used in the statement of principle I have adopted. And then 4322, paragraph, the first paragraph starting my lords, about 5 lines down towards the end of the line, but where, as for this purpose I assume to be the case here, the transfer is made to one who is not an organ of a foreign government, therefore cannot be equated with the state. And if the court reads to the end of that paragraph, it looks very much like indirect impleading. So,
Dollfuss does carry it a bit further, doesn't it? Because in that case, it wasn't at all clear that the government, the three governments, or any of them, or the commission to which they'd entrusted the gold, had any right to it at all. So what was state immunity was extended to a situation where there was an arguable claim that the gold was held as bailees by the Bank of England on behalf of the three governments.
yes, the court proceeded on the assumption that there was a bailment and that the three governments
Well,
were
I don't know.
entitled...
It didn't proceed on the assumption. Well, it proceeded on the on the basis that that was the case.
Yes.
And it said that the procedure was unsatisfactory, and it would have been better if there'd been a prima facie inquiry
Yes,
into that issue.
That's a separate question. So that's the question of what, before a state can set up its immunity or its claim to immunity, what must it show in relation to its claimed interest? But that's a question of evidence for the issue of state immunity to be determined. What the court did in this case was it proceeded on the assumption, as it were, or accepting the claimed interest, but its decision in relation to whether the state had immunity was premised upon the existence of that bailment. It's a separate matter as to how you establish to the court's satisfaction that you have a relevant interest that would entitle you to set up the
Yes,
claim.
I suppose the answer is there was certainly a bailment on any view. They had possession of it.
Yes.
Yeah.
But what wasn't in question was that they had some kind of possessory interest that would be interfered with, even if a claim was brought through the conversion vehicle as opposed to the direct claim for...
It's presumably a matter for the court to decide, though, whether or not there is, in fact, a proprietary right or possessory right in the relevant property.
I'm sorry, my lord.
It's presumably a matter for the court, is it, to
Yes.
decide in these cases?
Yes, there is case...
Whether the court, whether the defendant was the proprietor of the property.
Indeed.
Or had a possessory right in the property or not.
Indeed, and that's dealt with
I mean, that's all justiciable, is it?
Yes, that's dealt with in the State Immunity Act itself, and it must be supported by prima facie evidence. Section 6.4 of the Act requires that any such claim is supported by prima facie evidence. And before the State Immunity Act, that issue was also addressed at common law.
These various cases, Ms. Kaufman, if I understand them correctly, demonstrate that making property of the state, or for that matter, property which was in the possession of the state, the subject of adjudication, can properly be described as indirectly impleading. Fine. Do they help on whether anything else can amount to indirect impleading?
Well, the passage that we just looked at from Viscount Simons, which talks about, of course it talks about position in relation to property, because that's what the case was concerned with, but the passage at the bottom of 4318, as soon as it's proved that, quote, the subject matter of the action, now that could be any subject matter. The subject matter of the action, the defendant is the agent of a sovereign state, but in other words, the interests or property of the state to be subject to adjudication, the same result is reached. Now, one could apply that to a situation where one is dealing with servants or servants of the state acting in an official capacity who are, for example, imprisoning somebody. And when we look at Jones, we will see that Jones can be analysed through the prism of a case in which the servants of the state were, because they were acting in official capacity, individuals for whom the state was vicariously liable, and therefore, by impleading them, you are indirectly impleading the state.
Yeah.
So if we just summarise what we've seen from these cases, albeit they were all concerned with property, we accept that it is possible to analyse these cases as establishing a notion of indirect impleading which extends beyond property cases. There's no magic about the fact it's property. The magic about the fact it's property means that you can set up a direct impleading case because the state's property is immune. And in Jones, the court did something along those lines, albeit it analysed it through a slightly different prism, as we'll see in a moment. But what's critical about these cases is what is meant by impleading. And impleading has the very narrow meaning that I've already identified and outlined, which requires an adjudication of the legal interests, rights, duties, obligations of the state, with consequences for the orders that the court can make as a result being opened up following that adjudication. So if we can come then to Jones, that's in the first volume.
So could you just give me the section of the Act that you referred to?
I'm going to come to the Act, that's section 6.4, and I'm going to come back to section 6.4. But it's section 6.4, right at the end of section 6.4. It's a strange section, because it deals with property of the state that is not immune and then defines the property of the state that is immune by reference to the property that isn't immune in section 6.4. We don't, as Mr. Phillips, so 1696 in volume 1,
Yep.
as Mr. Phillips acknowledged this morning, Lord Hoffman's analysis of why a state is immune where a claim is brought in respect of the acts of its officials was an analysis which resulted in reading into the Act words to ensure that state includes its officials. And the analysis of Lord Bingham, which we weren't taken to this morning, proceeds on a slightly different footing, and albeit he doesn't in terms mention the necessity to read into the Act, those words, it's possible to read him as agreeing that that's the way in which effect is given to the immunity, which they found existed. But the relevant paragraphs are at paragraph 10 to 13. And at paragraph 10, on page 1707, 3 lines down, we have Lord Bingham referring to the wealth of authority to show that in such case the foreign state is entitled to claim immunity for its servants as it could if sued itself. And he then refers to a number of cases, none of which does he analyse on the basis that they have looked at the rules of attributability of state responsibility on the international plane. And if the court reads down quickly through, skims over 3 to 13, from the analysis, reviewing the 2004 Convention, and coming to 13, pausing at this point in the analysis, I think that certain conclusions, taking the pleadings at face value, are inescapable, that all the individual defendants were at the material times acting or purporting to act as servants or agents of the kingdom. Their acts were accordingly attributable to the kingdom. No distinction is to be made between the claim against the kingdom and the claim against the personal defendants. None of the claims falls within the exceptions in the 1978 Act. And then, so no reference to indirect impleading there. That comes in later when Mr. Phillips took us to this, when Lord Bingham is then looking at the Court of Appeal decision and setting out why he departs from the reasoning, and that's paragraph 31. And here, that's page 1716, it is clear that a civil action, 4 lines from the bottom of that paragraph, against individual torturers based on the acts of official torture does indirectly implead the state, since their acts are attributable to it. Were these claims against the individual defendants to proceed and to be upheld, the interests of the kingdom would obviously be affected, even though it's not named as a party. Now, the court is not, or Lord Bingham is not there, setting out a new basis upon which he is finding that the immunity of the state runs. He is simply referring back to his analysis earlier and saying that constitutes an indirect impleading. And the significance of that is he's not thereby, when he's referring to the interests of the state being affected, opening up a nebulous concept of what those interests are. He is saying that because the state officials are effectively standing in the shoes of the state's legal interests, or the state interests, are directly affected in the sense that there will be a legal determination of those interests which will purport to affect the freedom of the state to operate in respect of the activities that have been impugned. For example...
Why will it do that? I mean, is Lord Bingham here referring to the possibility of a claim for indemnity by the state's agents against the state? Is that the interest of the kingdom?
In my submission, it's on the basis that if one analyses it in this way, that as a matter of international law, the state is inseparable from the agents of the state. So, if one sues the agents of the state on the domestic plane, the relations between the state obviously operate on an international plane. On an international plane, you are suing the state itself. There is no distinction to be drawn. And that is the way in which they're effectively indirectly impleading. You are thereby determining the liability, according to your law, of that state. You are imposing upon that state your sovereign authority.
And is that what Lord Bingham is actually saying in this paragraph?
Well, he's not saying it in this paragraph, he's saying it earlier on.
But I read him here as saying that the interests of the kingdom are engaged because although the relief sought is sought exclusively against the individual agents of the kingdom, the interests of the kingdom itself would obviously be affected. Now that might be for one of, as it seems to me, two reasons. One, they might have a legal responsibility to indemnify their agents. The other, they might simply have an interest in the fact that their liability was in issue in some proceedings in another country.
But in my submission...
The latter is essentially what is being submitted by Mr. Eadie.
But in my submission, he doesn't mean that, and he can't mean that, because what he's doing here is he's simply summarising the situation as he's analysed it earlier on in the judgment. He's not purporting here to lay down a new basis of indirect impleading. If he were doing that, one would expect him to set out a proper basis for extending the doctrine of impleading beyond where it has ever gone before. He hasn't sought to do that in his earlier analysis. His analysis in 10 to 13, in paragraphs 10 to 13, doesn't at all attempt to extend the notion of impleading. It is entirely consistent with a narrow concept of impleading that he says, we sue the agent of the state on the domestic plane. What is the consequence of that for our relations on the international plane with the state whose agents they are? On the international plane, those agents are the state. We are effectively suing the state.
Well, that's what Article 4, which he quotes in paragraph 12, says. And I've just been looking at it. That's really the effect of the whole of the discussion in a case in the Privy Council, Jackamines and FG Hemisphere, where we were distinguishing between those who counted as the state and separate entities, which are also dealt with in the International Convention, which may exercise some sovereign activity, but aren't to count as part of the state. Yeah. So you lump everything into the state if you don't talk of employees or agents.
And you are here deploying and applying international law. So you have to look at the international plane to look at whether or not what you're doing on the domestic level is affecting your obligations under international law. And that's what he does. And it is a form of indirect impleading. He could equally have done it by saying, well, they are also agents of the state, and therefore, under our domestic law, the state is equally liable for their actions. But either way, the critical point is he's not extending the concept of impleading, and paragraph 31 simply cannot be read in that way. He's only summarising the conclusions he reached earlier on. So those are the domestic cases. Can we turn to the Act? That's again in volume 1. That's 1810, tab 10.
Yeah.
So the first section to look at, section 1. A state is immune from the jurisdiction of the courts. That's what it's immune from, the jurisdiction of the courts. Now, what does that mean? It means it's immune from having its legal rights, interests, obligations, and so forth determined by the court, and the judicial powers consequent upon that being imposed upon it. Section 1(2), just to be very clear, a court shall give effect to the immunity conferred by this section even though the state does not appear in the proceedings in question. That is not a provision concerned with indirect impleading. That is simply the provision that says it doesn't matter if the state itself does not claim state immunity, it is the duty on the court to confer it of its own motion. Section 14(1). Section 14(1), states entitled to immunities and privileges. The immunities and privileges conferred by this part of this Act apply to any foreign and Commonwealth state other than the United Kingdom. That's quite an important provision. It was a provision that Mr. Justice Leggett focused upon, but the UK is not immune under this, and one has to be very careful if the consequence of the reading of it is to confer immunity on the United Kingdom. References to a state include references to, and we don't need to be concerned with that. We then come to section 6(4).
But it does draw the distinction Lord Mance was drawing a minute ago between the state and a separate entity.
Yes.
Yes.
I mean, but that is a separate entity of the sort we were considering in Jacquemines, which was
Yes.
the Congolese state mining company.
Yeah.
Yes,
And-
exactly. It's a separate entity, but doesn't include
right.
the United Kingdom, and a separate entity that post-Jones does include officials of the state. See,
Sorry, separate entity. No, separate entity doesn't include.
but not to any, exactly, that does not include
Yes,
officials.
right.
They are not treated as a separate entity.
No, they're
they are
treated
part of the state.
yeah.
Exactly, I'm sorry. So before we get to section 6, what we run over are the exceptions to immunity in 3, 4 and 5. So 3 is commercial transactions. So when absolute immunity was replaced with the theory of restrictive immunity, commercial transactions ceased to be immune, contracts of employment, personal injuries occurring within the jurisdiction of the United Kingdom, and then we get to ownership and possession of property. And this is a strange provision. So one of the things we'll note is that it's only the state that is immune in section 1. So the way in which this Act operates is not to say the state and its property are immune, in contrast to the UN Convention. The state is immune, its property is then dealt with in section 6, and this provision sets out in 1, 2 and 3 circumstances where the state is not immune in respect of its property, and section 6(4) deals with where the state is immune. So section 6(4), a court may entertain proceedings against a person other than a state, notwithstanding that the proceedings relate to the property, this deals with indirect impleading, notwithstanding that the proceedings relate to the property which is in the possession or control of the state, or in which a state claims an interest, if the state would not have been immune had the proceedings been brought against it, or, in the case within paragraph B, if the claim is neither admitted nor supported by prima facie evidence. So you have to read from section 6(1) to 3 what is left out in section 6(1) to 3. What is left out is that which the state can still claim immunity in relation to, and section 6(4) then extends to that sphere of immunity any case in which the state is not directly impleaded, as long as the state itself would have been able to claim immunity, because it's not covered by section 6(1) to 3. But the important point here, for our purposes, is the only reference to indirect impleading in this Act is in section 6(4). And that, therefore, doesn't cover the circumstances in which the appellants are concerned with, and the notion of indirect impleading here is a narrow one It is impleading by subjecting the state to the jurisdiction of the court in the narrow sense of the terms. Finally, before we move from this Act, Section 15 on the same page 1820, so the next page. If it appears to Her Majesty that the immunities and privileges conferred by this part of this Act in relation to any state, and at B, are less than those required by any treaty, convention, or other international agreement to which the state and the United Kingdom are parties, Her Majesty may, by order in council, provide for restricting, or as the case may be, extending those immunities and privileges. And the obvious point to make here is there has been no extension by order to extend the concept of immunity to cover the broad conception for which the appellants contend. So common law doesn't assist, the Act itself doesn't assist, and so the appellants are now forced to resort to the international plane and to argue that as a matter of customary international law, the meaning that they contend for it is applicable. And the first point to note is that they rely on a single international instrument to found their claim, that customary international law so requires this construction. And as my lady, Lady Hale, has already noted this morning, it's not yet in force. It hasn't been ratified by the sufficient number of states. It requires 30 ratifications. And when I looked yesterday, it's got 19 so far, and only 28 signatories, of which the United Kingdom is one. So it's not even a binding treaty, but we are to conclude that it represents customary international law. So let's just remind ourselves of what must be proven before a rule can be said to represent customary international law. Volume 12 and page 5716, it's the jurisdictional immunities case, tab 98. And on page 5716, paragraph 55, follows that the court must determine, in accordance with Article 38(1)(b) of its statute, the existence of international custom as evidence of general practice accepted as law confirming immunity on states, and if so, what is the scope and extent of that immunity? To do so, it must apply the criteria which it has repeatedly laid down for identifying a rule of customary international law. And it refers to the North Sea continental shelf cases. The existence of a rule of customary international law requires that there be a settled practice. Moreover, as the court also observed, it is of course axiomatic that the material of customary international law is to be looked for primarily in the actual practice and opinio juris of states, even though multilateral conventions may have an important role to play in recording and defining rules deriving from custom, that is, recording or defining rules from custom, or indeed in developing them. And then if the court could just read the next paragraph, because this was a case looking at what the law, that customary international law was in relation to state immunity. And so the court actually focused on what the best evidence is in identifying customary international law in respect of that particular rule. So unsurprisingly, given that we're dealing with a practice of states which is about subjecting a foreign state to the adjudicatory powers of the judiciary, one is going to find evidence of practice in the decisions of courts, or where nations legislate for it, in their legislation. That's where one has to look for the state practice. And then opinio juris can be found in assertions by states claiming immunity that international law accords them that right. So one can see it in objections within within proceedings to the assertion of the adjudicatory powers of the court. Next, 28, volume 28, tab 224, MS 11,139. And what we have here are the International Law Commission's text of the draft conclusions on the identification of customary international law.
11,239.
224, page 11,139.
Thank you. Yes, got it. Thank you.
Volume 1.
Volume
28.
28.
28.
And there are the first 5 parts are all important, and I will leave the court to read those in your own time. But part 5 just deals with treaties and the significance of treaties in trying to identify a rule of customary international law. A rule set forth in a treaty may reflect a rule of customary international law if it is established that the treaty rule codified a rule of customary international law existing at the time when the treaty was concluded, has led to the crystallisation of a rule of international law that had started to emerge prior to the conclusion of the treaty, or has given rise to a general practice that is accepted as law, and thus generating a new rule of customary international law. The point is, you have to look outside the treaty for the practice and the opino juris that underpins the general rule that it then reflects.
That would apply, would it, to a bilateral treaty?
Yeah. Applies to any treaty.
Mm-hmm. Well, some treaties are so generally adhered to that
Yes.
they, like obviously classically the United Nations Charter.
Yes, exactly. But
They
one
will
is
be-
able to
even
say
be treated as binding the handful of non-adherents.
yes. But the 2004 Convention is not one such. So there is no way that one can simply appeal to its terms and say that is customary international law. You have to look at state practice, you have to look at opino juris, and you have to establish it that way. So where does that leave the appellant's reliance upon the 2004 treaty? When the Rahmatullah case was before Mr. Justice Leggett in the High Court, he invited the appellants to provide evidence of state practice supporting their interpretation. And we can see that in the core bundle, volume 2, page 978, paragraph 80.
Yep.
They didn't provide it. We've now had a year since that decision for the appellant to conduct his or her researches and come up with some evidence of state practice. We have nothing. Not one case emanating from any jurisdiction, not one bit of legislation, not one piece of opino juris, nothing. But what we've found and what the interveners have found, and will no doubt take the court to in more detail, are some cases that absolutely contradict that position. So just for your lordship's note, we refer to one of them, which was considered both on appeal and at first instance in British Columbia, and that is United Mexican States and British Columbia. And that's in volume 20 at tabs 153, which is the first instance decision, and at 150, the Court of Appeal decision. And that is also dealt with in our case at paragraph 62, core volume 1, page 198. And I won't ask your lordship for my lady to turn it up now. It's a very useful judgment at first instance of what is meant by impleading, which is entirely consistent with the way we submit all the courts, whether international or domestic.
Page 198.
I'm so sorry.
Whereabouts in your print?
It is at paragraph 62, page 198. And it's paragraph 62. So 153 is the first instance, 150 is the appeal. And if I can give the relevant paragraphs, if your lordships do want to look, they are in our note, but it's in the first instance decision at 153 of volume 28, it's paragraph 121, 125, 133 to 135, and the Court of Appeal simply agreed with that reasoning. So, on that analysis, the appellant's argument in reliance on the convention just collapses. They have absolutely no evidence to support a case that this reflects customary international law. And just very quickly, it would be extremely surprising if that were the case. And if one just thinks for a moment when this convention was introduced, it was a long, long time in the making, over 12, 13, 14 years in the making. It began just after the collapse, the work on it began just after the collapse of the Soviet Union, at a time when there were still big divisions between states as to whether the absolute theory of state immunity or the restrictive theory, which carved out an exception from state immunity for the commercial transactions of a state. There was still a lot of dispute about which of those two theories applied. So to imagine that within the course of the 14 years it then took to bring it into force, the practice of all states, or a sufficient number of states across the world, would have converged on all matters when it had started from such a point of division, well, it would be surprising, to say the least. In any event, the preamble makes clear it doesn't profess to represent customary international law. If we turn to the Convention, Volume 1, Tab 6, page 1734, and to the third, to believing that an international convention, this is on page
which page?
1734.
Okay.
Believing that an international convention on the jurisdiction and immunities of states and their property would enhance the rule of law and legal certainty, particularly in dealings of states with natural and juridical persons, and would contribute to the codification and development of international law and the harmonisation of practice in this area. It's not claiming for a moment that harmonisation has already taken place, and this reflects it. And also, our own courts, the Court of Appeal recently in Bankabouche, has reached exactly the same conclusion. That's Volume 2, Tab 18, page 2039. The relevant paragraph being paragraph 29. But before looking at paragraph 29, the introduction to paragraph 29 starts on page 20. Yes, it starts at page 2057, the introduction to what is then said on the next page, 2058.
Mr. Eadie's trying to get brownie points. Successfully.
So, on paragraph 27, we can see that the Court of Appeal is considering the case of Sabah el-Lail and France, and the court then, we can see there's a quote from the court, at the bottom of the paragraph, it turned to proportionality and considered a case called Kudak, and if the court then reads paragraph 57 of the Sabah judgment, which is at the top of page 2058, we can from there see the criticism to which that was subjected by Mr. Landau on behalf of Libya at paragraph 29. And if the court reads down from there to 3, we can see that the court agreed. You couldn't look at the convention and just assume it reflected customary international law. And what the Court of Appeal then went on to do was it went on to look at Article 11 and, by reference to state practice and so forth, to test whether or not Article 11 did in fact represent customary international law, and concluded that it didn't.
Where did it conclude that?
Paragraph 36. I'm sorry.
And Article 11 is about employment, is
Yes,
that right?
it's about employment.
Yeah.
There would seem to... I'm sorry, if I can just... Well, it comes from the... Yeah, we'll get that reference for you. If I can come back to that, we'll get the reference. The appellants relied on another.
When the court points out here, in paragraph 36, that in the present Court of Appeal in Belhaj, the court held that the provisions of the Convention in Article 6, I think, extend beyond the requirements of customary international law. I mean, it all depends what you mean by affect the interests and activities, doesn't it? If you give that a meaning along the lines that you're suggesting, then it's a restricted meaning, but it would be consistent.
Exactly. I mean, I'm going to come on to our next argument, which is actually that if you read it properly, it is entirely consistent with our argument.
The argument against that is that there's a previous reference to rights, but nonetheless, interests can certainly mean legal interests and probably activities.
Yeah, and if we will come on in a moment to look at the provisions, construe them in the context of the convention as a whole, look at all the drafting material relevant to the final terms, and we will be making a submission that actually, properly read, it is so limited. Paragraph 46.
Paragraph 46, I was about to say.
Thank you, I'm grateful. Paragraph 46.
Went through a lot of state practice that wasn't consistent.
Yes. Yeah. So, just for the court's note, the appellants relied upon a case called London Steamship Owners Mutual, which is at volume 2, tab 20, page 2166. And it is right that the Court of Appeal looked at the draft articles, but at paragraph 62, which is on page 2185, they did so as merely illustrative of a basic principle that is widely accepted. So we accept that there will be within the 2004 conventions the articulation of principles that do reflect customary international law and be widely accepted in the sense that Lord Sumption meant, and that one won't need to look beyond that. But that doesn't take the appellants anywhere in respect of Article 6.2. So what value then do we place upon the commentaries upon which the appellants rely? Well, looking in the hierarchy of relevance to establishing the existence of international law, we can see that they come very low down, and they certainly can't trump the absence of any evidence of state practice. And so we would say, really, there's no value to be placed on them. But in any event, none of the commentaries actually support the construction for which the appellants contend. We refer to some of the relevant commentaries at paragraphs 65 and 66 of our case, page 200 in Core Volume 2, and for the court's note as well, an article or an excerpt from Fox and Webb, Volume 23, tab 182, page 9239. There is also the expressions by some of the states themselves in the report of the Secretary-General on the Convention, which is at volume 130, tab 17, volume 130, page 7597.
Sorry, what was the reference again?
This
Muddled
is-
there. Which bundle?
Volume 17,
17, yes.
tab 130. First stop, 7581, Australia. This was the first draft in 1991. It's a valuable contribution in paragraph 1 to the development of the law in this area. However, it considers that some of the provisions could benefit from some further improvement by the working group. Article 6, at 7582, Australia considers, in part 2, paragraph 9, that Article 6, paragraph 2b is too wide. Its effect is that a proceeding will be considered to have been instituted against a foreign state in cases where it could not be said that the state was a party to the proceedings, but where a determination by a court affects the property rights, interests and activities. A narrower formulation would be preferable. The observations of the United Kingdom at MS 7601. At paragraph 2, at the bottom of that paragraph, the aim must be, 3 lines from the bottom, to establish on a long-term basis common rules in this area which are fair both to states and to those who do business with them. The United Kingdom has assessed the draft articles in this light, so it's on a long-term basis. And then, at 7602, we have, under paragraph 7,
Sorry, what page again?
paragraph 7 on 7602, the reason why international law denies a state the right to exercise jurisdiction over a category of defendants present in its territory or undertaking activity there is expressed in the maxim par imparem non habet imperium. It follows that the notion is bound up not with how closely the activities of the defendant are connected with a foreign state, but rather with whether the defendant itself forms part of what should be properly understood to be the foreign state. The US concerns MS 7607.
Now, this is all a discussion of a draft, is it?
Yes, but many of the articles remained the same. We'll see that Article Section 62B was drawn actually more widely after this, even though the intention...
Can we see the form in which it was when it was being discussed?
Well, we're going to see that in relation to Article 62B. We will see that in a
I think
moment.
one gets the essence of it from paragraph 9, doesn't one?
I'm sorry, my lord.
7603.
Yes, well, 7582, paragraph 9, the then form of the draft seems to have been the same as it is at the moment. Property rights, interests or activities of that other state.
Yes, sorry, that's right. They had been redrafted in light of criticisms that had been made of an earlier draft.
Right.
So in respect of Article 62B, these comments are
On this particular
ultimate
on the ultimate
provision.
draft.
Yes.
Yes.
So the United Kingdom's or Australia's suggestion that a narrow formulation would be preferable came to naught.
Yes, came to naught. And the United States at 7607 made some specific reference to also to Article 62B. At the bottom, paragraph 10, with respect to paragraph 2b of Article 6, we are concerned about the potential breadth of the provision that considers that a proceeding has been instituted against a state in any case in which the proceeding in effect seeks to affect the property, rights, interests and activities of that other state. And if the court reads to the end of that paragraph.
Sorry, which page was that?
That is at 7607 to 8, at the bottom, paragraph 10.
I got it.
So that's as far as we go on the Pinot Juris, which doesn't support that wide reading. If we can then turn to the provisions of the Convention themselves, because this is where we've moved on to our submission that in any event, Article 62B doesn't fall to be read according to this extensive reading, but has a narrow interpretation entirely consistent with the narrow formulation of exercising jurisdiction for which we contend. The starting point, so this is volume 1. Volume 1, and it's at tab 6. The starting point is with Article 1, page 1735. A state enjoys immunity in respect of itself and its property, so we can see that's all wrapped up into one, from the jurisdiction of the courts of another state, subject to the provisions of the Convention. And then if we can turn to 5,
That was 5.
a state, it's 1735. A state enjoys immunity in respect of itself and its property from the jurisdiction of the courts of another state. Again, from the jurisdiction. Then we have to read Article 6, which is immediately after it, in light of that. And we don't need to concentrate on Articles 6.1. A proceeding before a court of a state shall be considered to have been instituted against another state if that other state is named as a party to that proceeding, or is not named as a party to the proceeding, but the proceeding in effect seeks to affect the property rights, interests, or activities of that other state. Now, in my submission, you have to read all of these together, and so subjecting the state to the jurisdiction is akin to instituting proceedings against it, that is, or naming a state as a party to the proceedings. And what is the consequence of that? The consequence is that the court can then exercise its judicial authority over that state, and one therefore has to read Section 6.2b or Article 6.2b consistently. It's the equivalent of indirectly making the state a party to the proceedings by seeking to affect its property rights, interests, or activities. You can have a legal interest, or you can have an interest that isn't even legal, but the state can seek to affect it by imposing its laws upon that interest. So the interest of the state, which has illegally requisitioned a ship, for example, it has no legal title or no legal entitlement under its own laws to a particular piece of property that it has in its possession. It's not unless it's got an interest in it, it's got the possessory interest it has.
Why do you need to defend the terminology of it in the light of the criticisms that you've brought our attention to?
I don't. I don't, but this is simply another string to our bow, which is to the effect, actually, it doesn't go anywhere near as far as the defendant says. So I won't spend time on that, other than to say that there is a lot of commentary. Again, I think we've referred to it in our case that supports this analysis. And perhaps for the court's note, if I can just highlight what those are. Professor Zachary Douglas, Volume 23, tab 193, page 9542. Fox and Webb, Volume 23, tab 182, page 9199, at page 9262. O'Keefe and Tams, Volume 23, 186, at page 9408. And then in Volume 30, tab 243, at page 298. Orakelshvili, and at page 286 as well, and 282 on whether it represents customary international law. So that then is our submission on the 2004 Convention. And very quickly, the significance of the ICJ jurisprudence in relation to its own jurisdiction. Now, the appellants say this is analogous to state immunity. And we submit, well, that's all very interesting, but what is its relevance? What bearing does it have upon the meaning of state immunity? Because it's certainly not something that we can look to try and identify what customary international law is, because state immunity is concerned exclusively with the exercise of a state of its jurisdiction over another state. The ICJ is not a state, and it is not concerned with the exercise of a state's jurisdiction over another state. It is concerned only with the exercise of its jurisdiction as an international court. So it has absolutely no bearing upon the question of what customary international law is, so far as state immunity is concerned. And in our submission, therefore, when in paragraph 42 of the Court of Appeal's judgment and at paragraph 78 of Mr. Justice Legate's judgment, so the Court of Appeal, paragraph 42 is at Core 2, page 351, and 78 of Mr. Justice Legate's judgment is at Core 2, 977, when both of those courts distinguished the ICJ jurisprudence on the basis it had no bearing on state immunity, they were quite correct to do so and quite correctly identified that that is really concerned with the jurisdiction of the ICJ, which rests upon the consent of parties. That said, in our submission, when you actually examine the way in which the court decides whether or not it is unable to entertain proceedings because it doesn't have the consent of a third-party state, it actually applies a conception of what impleading is, which is identical to the conception for which we've been contending. And we can hopefully take this very shortly. The first three cases are all in volume 16. We start with monetary gold, tab 114. Page 7256. So, an international tribunal was set up to decide whose gold, the gold found in Rome, whose gold it was as between Italy and Albania, both of which laid claim to it. And that tribunal decided that it was, in fact, Italy's gold, not Albania's gold. And the arbitration decision was final, subject to the right of both Albania and Italy to apply to the ICJ to determine whether or not, in fact, in the case of Albania, whether England had a claim to that gold, because it had also been determined between the state parties who were responsible for administering the gold, that the gold that had been identified by the arbitrator as belonging to Albania should be given over to the United Kingdom in satisfaction of a ICJ ruling in their favour. So Albania was given an opportunity within 19 days of the judgment that this gold was its, to apply to the ICJ to overturn the ruling that the money should be given over to the United Kingdom, the gold should be given over to the United Kingdom. Italy was given a right to apply to the ICJ for a determination that that gold should actually be handed over to Italy as compensation for wrongdoing, which it was alleged Albania had done pursuant to a particular statute. So that was the position. And as Mr. Phillips said, Albania didn't apply to the ICJ, but Italy did. So Italy's application was, give us the gold, make an order that that gold comes to us, on the basis that Albania perpetrated an international legal wrong against us for which it must make compensation. And unsurprisingly, the ICJ said, well, we can't do that because the very subject matter of the claim that you are making is a determination of the international legal liability of Albania. And one can see how it is a legal determination. It's not simply a finding that Albania acted illegally. It is a determination of that illegality with consequences for Albania's right to that property. it ceases to have the right because it is then ordered to make compensation. So that is a very, very clear case of indirect impleading in the sense that it will lead to consequences. And just for the court's note, the important parts, bottom of 7280, and then on page 782, the first two paragraphs, and the last few lines of, and the last paragraph effectively on page 7282, that little paragraph, all the way through to the first paragraph on 7284. And that is all that the court needs to read there. East Timor, in the same volume, tab 110, page 7026. Paragraphs 13 to 18 contain the critical factual background. 7040 to 7044. Effectively, Portugal, which had colonised East Timor in the 16th century and at the time of the invasion of East Timor by Indonesia, was so far as the UN General Assembly resolution was concerned, a non-self-governing, or rather, the East Timor was a non-self-governing territory of Portugal's. Indonesia then invades, and Australia firstly de facto recognises Indonesia and then later actually enters into arrangements with Indonesia to agree the delimitation of the continental shelf between East Timor and Australia.
So what's the upshot of all this?
So the upshot of this is, and if we go to 23 to 27 of the judgment, we can see in paragraph 23...
We've looked at this, yes.
Yes. Well, again, just to summarise this, the issue here was whether or not there was any treaty-making power on the part of Australia. And it was a challenge to Australia's actions in relation to East Timor on the basis that it had dealt with Indonesia, and Indonesia had itself unlawfully annexed East Timor. And the court concluded at 7058, that the effects of the judgment requested by Portugal would amount to a determination that Indonesia's entry into and continued presence in East Timor are unlawful, and that as a consequence it does not have the treaty-making power in matters relating to the continental shelf resources of East Timor. Indonesia's rights and obligation would thus constitute the very subject matter of a judgment made in the absence of that state's consent. So it wasn't, again, simply a finding of illegality. It would be a finding, the consequence of which would be you, Indonesia, do not have the power to enter into treaties in respect of this territory. That is far more than a simple finding of illegality. It is a determination of its legal rights on the international plane.
But Indonesia would not have been bound by that decision.
No, quite.
No, but equally, and the court said in terms, the fact that it wouldn't have been bound was not what's relevant. The court simply doesn't have jurisdiction to enter into the question whether or not it's bound because it amounts to a legal determination against it. And it would unravel the treaty agreed between Australia and Indonesia. It would necessarily have that consequence.
Well, it wouldn't, would it?
Well, it wouldn't necessarily. The problem here was that there wasn't a property issue analogous to the one in monetary gold. The problem here was that they were not prepared to decide the rights and obligations of Indonesia in proceedings to which not only were they not party, but were under no obligation to become party. And I think that's the suggested analogy put forward against you for the relevance of this case. What is being said is there is a principle of international law under which, even though a party wouldn't be bound because it's not a participant in the proceedings, you should not decide something which is central to the dispute and it involves a decision about the extent of its rights and obligations in circumstances where it's under no obligation to be present and isn't.
But there is a distinction here in that there is a necessary determination of its rights in international law to agree treaties in respect of this particular territory. The fact that there won't be a legal consequence is akin to the restrictions in state immunity on the enforcement of judgments. It doesn't mean you're not subjected to the adjudication of the court, that there will not be a consequential enforcement of that judgment. You remain subject to the adjudication. Enforcement is something else.
But it's not binding, so how could the question of enforcement even arise? I think another way of looking at this is that it's more interesting as a parallel to the arguments on foreign act of state and to Kuwait Airways. To Butte's Gas. I mean, it's quite a close parallel to Butte's Gas and Hammer, or Occidental.
In our submission, it wouldn't be a parallel. I mean, Mr. Hermer will deal with this, but it wouldn't be a parallel, again, on the basis that what one is dealing with here is a question of the jurisdiction of the ICJ and issues...
Yes, but I mean, we've been asked to consider whether Butte's Gas and Occidental has, at the international level, any homologue, and this might be said to be quite a close homologue.
Well, I'll leave Mr. Hermer to deal with that. Certainly, so far as state immunity is concerned, this has absolutely no bearing. Howsoever one analyses this has no bearing upon what state immunity is and what, as a matter of customary international law, and what state immunity is under our 1978 Act. It is concerned with an entirely different matter, which is the jurisdiction of the ICJ.
I mean, in Monetary Gold, they appear on that last point to have taken the view that although they were, of course, applying the jurisdictional limits imposed by their statute in that respect reflected a general rule of international law. If one looks at page 32, MS page 7282 of Monetary Gold, to adjudicate upon the international responsibility of Albania without her consent would run counter to a well-established principle of international law embodied in the court's statute. So there does seem to be a conception that there is a more general principle engaged here than simply the statute determining the jurisdiction of the ICJ.
But that principle is not articulated as a principle akin to, or that is, state immunity.
So we have to infer what the principle is from the description that they subsequently give of it, and the description which, by reference to Monetary Gold, is given to it in the Timor case.
Well, in my submission, even if they are considering that is a principle that is, in some sense, akin to state immunity, it is not the same as state immunity. It is not, this does not do the job of demonstrating what state practice is in this area. It takes one absolutely nowhere. It is simply an example of what the ICJ does.
You're saying, I think, that there's a fundamental difference, or maybe, between the rule that the International Court only has jurisdiction by consent and the rule applied in other states when dealing with with cases which affect third states. Now, what is the difference?
Well, the state immunity is not based purely on consent. So, for example, we have the commercial exception, which is not based upon consent, the exception based upon personal injury arising within the jurisdiction, that is not based on consent. There is no immunity in respect of those matters, and that's not a matter of consent.
So it's already narrower.
It's already narrower. It's already a narrower principle than this, which is exclusively one of consent.
Consent is relevant because the immunity consists in a right not to be subjected to the jurisdiction of a domestic forum without your consent. That is the nature of the immunity. And it's the same principle, or a very, very closely similar principle, that seems to be engaged here?
Well, there's an important distinction because the principle here is one of absolute immunity, consent or nothing. And the principle of state immunity is not that. It is a far narrower
It is in
conception.
relation to acts jure imperii, isn't it?
Well, no. Look at the PI exception, the personal injury exception. That can be in relation to sovereign acts of the state.
Can it?
Yes.
How does the personal injury?
Yes. So if the torture takes place, or if the torture were to take place in the United Kingdom,
Yes.
by a state official, they would have no immunity.
Yeah.
So it's a territorial exception, but that's nothing to do with consent. It's also worth looking, before I leave this, there are two other cases I want to briefly look at. One is now the Nauru case, which is at 7062, still in the same volume, tab 111.
Yeah,
Certain
part of that's
phosphate lands.
quoted in the East Timor judgment, yeah.
Yes, but it's worth actually looking at the facts of that. It is quoted. I'm not going to detain the court long on this. I would simply ask the court to read it, and because this is a case where the court said there is no problem on this case. We are not prevented from adjudicating, even though it recognised that there would be an effect upon the interests of the missing state.
Can you tell us
Yes.
which paragraphs we find the bullseye in?
So the key passages are on page 7106. And the court really needs to read the whole of that page. But what the factual background is at page 7096. Paragraph 40 through to 43, and then 46 to 47.
And the principle we find at paragraphs, 54 to 5, is that right?
And then it was at paragraphs 54 to all the way down to the end of 55.
Not a prerequisite.
Yes, it's not a prerequisite. Except that there might be effects upon the legal interest.
Well,
And then lastly,
I mean, that's subject to the proviso, which essentially is referring back to East Timor and monetary gold, isn't it? Provided that the legal interests of the third state, which may possibly be affected, do not form the very subject matter of the decision applied for. Page 7106, an inch and a half down.
but the point that was being made there was that there would be no legal determination of that state's liability in respect of matters that form the very subject matter of the decision. We turn last to Larson, which is an arbitration decision, volume 28, tab 223, 11,089.
So 11,089.
11,089, yeah.
So which bundle again?
This is volume 28. $11,089. Larson and the Hawaiian Kingdom. James Crawford, Professor Crawford was the president of this arbitration tribunal, and Christopher Greenwood was also a member of the tribunal. And if the court just briefly reads the head note. Then there's a useful summary of the monetary gold principle, and then at (11.18 to 11.24), there's a useful analysis of what is meant by exercising jurisdiction over a state.
Yep.
And 11.24, an important passage we submit.
Well, that's the international law equivalent to the principle applied in Kuwait Airlines, isn't it?
Yeah.
Not entailing or requiring any legal assessment or qualification of that party's conduct. No, in my submission, it's not. It's saying that what must not be the implication of this is that there is a legal qualification of that party's conduct, that the actual decision itself must, in some sense, impose, albeit it's not going to bind the party, but impose a legal qualification on its conduct. That is, assert some kind of authority as a necessary part of determining the rights of the other parties.
Well, it's a legal assessment or qualification of the party's conduct or legal position.
Yes, a qualification
Quite
is
wide.
nothing to do with having to assess as a matter of evidence. A qualification is qualifying what it is that that other state can do by law.
Well, that's an alternative, though, legal assessment or qualification.
Well, in my submission, the proper reading for legal assessment there is legal determination. It is the determination as opposed to a factual finding, because that's what's being contrasted. So if you make a finding of fact to which no legal consequence attaches, that this tort was committed or that this conduct was perpetrated that amounts to a tort, that is different from making a legal assessment, namely a legal determination, which thereby has implications by way of qualification of that state's conduct. And then at paragraph 12.3, one can see what it is that was...
I mean, this is analogous at the very lowest to Dolphus Meek, because the United States government must be in possession of Hawaii, and this gentleman was seeking to say that he represented a separate kingdom and they didn't have any right to be there.
Exactly. So it was necessarily going to entail a determination, a legal determination of those rights and interests of the United States. And one can see it at 12.3 in terms of what was being sought. So, my lords and my lady, in our submission, the ICJ cases don't take the appellants any further forward, and we are left with an appeal for an extension of the application of the doctrine of state immunity, which is, as we said at the outset, wholly unsupported by the common law, the 78 Act, customary international law, or the ICJ jurisprudence.
Just going back to Article 6, 2b, which you say doesn't apply on the facts. Why, in a sentence, do you say that?
Why does Article 6.2b
Why do you
not...
say that? Yeah,
Article 6.2b doesn't apply because it doesn't represent customary international law. So even if one gives it the wide meaning for which...
Just a matter of meaning. I've got your various other points.
So why does it
Just
not
a matter
mean...
of construction of
So the point there is that one has to construe that in the context of the other articles. So one starts with Article 5, a state enjoys immunity from the jurisdiction of the courts. Then go to Article 6, A state shall give effect to that to state immunity, that is, immunity from the jurisdiction, by refraining from exercising jurisdiction in proceeding before its courts against another state. And then that's simply the provision that the court must determine of its own initiative. If one moves to 6.2, a proceeding before a court of a state shall be considered to have been instituted against another state if that other state is named as a party to that proceeding. So that's the institution of proceedings against a state, which is akin to subjecting a state to the jurisdiction. It has to be read in the context of Article 6, Article 5 and Article 1, which is also making clear that what this convention is concerned with is giving immunity to a state from the jurisdiction. So if subjecting a state to the jurisdiction is naming it as a party in the proceedings, what does that mean? That means you are then able to assert judicial authority over that state by making a determination of its legal rights, obligations and so forth, and thereafter making any of the orders that a court is empowered to make once it has determined issues of liability. Hence, one has to read section 6.2b in an equivalently restricted way. So it is only where a state, when not named as a party, is going to be implicated in proceedings because a legal determination in respect of it is going to follow, that it is impleaded, as it were, and 6.2b applies.
And I think it's said on the other side that actually this is a very broad expression.
It is.
That you haven't given sufficient meaning to the expression interests or activities, for example.
Well, the activities could be, for example, the activities of the state in torturing people. That's an activity. It could be the activities or the interests of the state in torturing people. It could be the interest that the state has in holding on to the property that it stole. That is an interest. Now, if the proceedings are going to implicate the state because they're going to order that that property that it stole should be given back to the rightful owner, that is a proceeding that will implead the state, albeit indirectly, if, for example, that property is held by an agent of the state. Unless I can be of any further assistance.
Is there no particular help in the doctrine in textbook writers? You may have cited some of them. I was just looking at the formidable list of commentators we have. Does none of them carry the matter any further?
In relation to 6.2b?
Yes.
Yes, and I did...
You gave us a list.
I gave you a list.
That's just those
Yes.
three you
Yes.
mentioned also. Yes.
Yes.
Right.
Yes, and just to be
Douglas
clear
Fox,
about where in our case we deal with this, this is at paragraph 46 in our case, page 192, MS 192, the meaning of Article 62B, and we go through the commentators. And we set
gave us
out...
4 of them, yes.
Yeah.
Thank you very much. Thank you. Mr. Hammer.
Some days like this, you realise stopping at 4 o'clock is a good idea.
My Lords, my Lady, Foreign Act of State Doctrine. The appellant's submissions can be reduced to 3 core propositions. Firstly, they say that a freestanding doctrine of non-justiciability exists, founded on the principle of sovereign equality, and applies whenever a court is required to assess the legality of foreign state acts other than commercial transactions or acts of foreign courts. That's their first proposition. Secondly, they contend that it applies irrespective of whether the foreign sovereign commits the impugned acts inside or outside of its sovereign territory. Thirdly, they argue that whilst a breach of fundamental rights can amount to an exception, it cannot do so unless that breach has already been proved or is admitted. All our submissions will seek to show that in respect of each of these points, far from reflecting any established rule of English common law, their adoption would mark a radical and unjustified extension of it. It would also be an extension made in isolation, and that is because, as I will seek to demonstrate, the doctrine is not required by any rule of international law, let alone customary international law, and in the form contended for by the appellant, the doctrine is not found in the municipal law of any other common law or civil law country. The United States once had a doctrine, in fact still has a doctrine with the same name, and it was once said to be based upon the notions of sovereign equality. But since 1963, that has no longer been the case. It is now based upon their distinct constitutional notions of separation of power, and in any event, even where it applies, is determined on a case-by-case basis. It is quite different to the concept contended for by my learned friends. In Australia, insofar as the doctrine has been said to exist, then any suggestion that it applies only to proven allegations of breach of fundamental rights has been emphatically rejected by their courts. Thus, no other country seeks fit to give effect to the principle of sovereign equality by the development of judge-made law in the form that the appellant says is required and with the wide-reaching consequences contended for. My lords, my lady, I'm going to split, if I may, my submissions into two parts. The first part, on which I will spend most of my time, addresses our primary position. That is, that the narrow act of state doctrine, as identified by Lord Wilberforce, is in essence no more than a choice of law rule and not a broad doctrine of non-justiciability. There is a critical conceptual distinction between rules of justiciability and rules of choice of law. Justiciability is about whether or not the courts have the power to decide the case at all. It defines the limits of judicial competence. Choice of law is about what rules the court must apply if they have the power to determine a case. Lord Wilberforce sought to distinguish these two concepts in Buttes, but unfortunately our courts have often wrongly elided them. Save for the narrow rule of act of state doctrine, there is no additional rule amounting to a freestanding doctrine of non-justiciability based on act of state. Rather, whether a claim touching upon foreign countries can be adjudicated upon by our courts will fall to be decided by general principles of justiciability. And these were the principles clarified by this court in Shergill. They require, in the context of this claim, to ask whether the issues in question extend beyond the constitutional competence assigned to courts under our conception of the separation of powers, in particular as against the competence of the executive in matters directly affecting our relations with foreign states. This, my lords, my lady, is the approach taken by Mr. Justice Leggett in Rahmatullah, and that is our primary case. Our alternative case, and the second part of my submissions, is based upon a far broader notion of acts of state found in the Court of Appeal judgments in Belhaj and indeed in UKOS, in which the choice of law rules and the principles of non-justiciability are elided to produce a discrete foreign act of state rule of non-justiciability premised on a prohibition against sitting in judgment on foreign states. Now, if contrary to our primary submissions, this does represent a discrete doctrine separate from Shergill notions of non-justiciability, then we will seek to rely upon the territorial limitation, as has been identified in those cases, and of the non-application to cases concerning breaches of fundamental rights recognised and respected by the common law. And we will seek to show that the defendant's arguments on these limitations are wrong in principle and would render the right of access to a court nugatory in practice. Now, before turning to our primary submissions, could I make a number of opening observations that are relevant to both? The starting point of the Respondents' analysis is the principle that it is the obligation of courts to determine disputes properly brought before them. This reflects two interlinked fundamental principles of our common law, namely the right to a remedy for legal wrongs and the right of access to a court to have criminal and civil rights determined. There can be no sensible dispute on the pleaded allegations that the respondents have suffered legal wrongs, insults to physical integrity, imprisonment without legal sanction, and rendition are prohibited in municipal, common and civil and constitutional laws, regional conventions, and reflect fundamental prohibitions in international law. Now, it's obviously no part of the respondent's case that the principle of a right to a remedy or access to a court in cases concerning foreign relations is absolute. Obviously, it is not. It can be circumscribed by other rules of law, most relevantly here, the law of state immunity. A claim can also obviously be deprived of a right to a remedy because of non-compliance with procedural rules. But a rhetorical question can be posed. If a claim brought as of right before courts is not precluded by a rule of customary international law or statute and does not fall foul of British notions of separation of powers, why should the common law right of access to the court be ousted? Now, in order to oust that right to a remedy, the competing rule of law capable of ousting it has to have at least two characteristics. First, it must be based on a principle that is capable of being recognised as requiring precedence over the right to the remedy. And secondly, that principle must be capable of being identified and defined with clarity and capable of ready and consistent application by the courts. It must apply in a way that people understand. Few, my lords, my lady, would argue that the jurisprudence in the English courts touching upon the doctrine of foreign acts of states has displayed either of these characteristics. It is an area riddled with ambiguity, with no clear guiding principle, and no explanation as to why, as a rule of common law, it should take precedence over access to a court. Now, that much is obvious from the fact that this court is presented with two appeals in which the judges reach different conclusions as to what the nature of the doctrine is, when it applies, what its limitations are. Albeit they reached the same result in the end, but different conceptions of acts of state by both courts. Now, the criticisms of the English approach to foreign act of state doctrine and other closely related decisions about justiciability of issues concerning foreign states are well known and long established. Lord Wilberforce himself in Butts commented that it was a generally confused topic, caused not least by the indiscriminating use of the phrase acts of state to cover situations which are distinct and different in law. See 930F of his judgment. And both the judgment of Mr. Justice Leggett and the Court of Appeal in Belhaj cite the criticisms of Dr. Mann in respect of the Foreign Act of State. Now, as my Lord Sumption mentioned yesterday, that might be the criticisms of sore losers at Herbert Smith, but of course Dr. Mann, one of the most respected and applied commentators on private international law, and it is worth just looking at the first page of his chapter on Foreign Act of State before we embark upon looking at the cases. And my Lord and Lady will find that in volume 25, tab 205, MS 10161. And if we turn to 10168.
Sorry, did you say volume 25?
I did, my Lord, yes.
Tab?
Tab 205.
10,168.
Could I just invite the court just to read that first page of Dr. Mann's work?
That could be applied to an awful lot of things.
That's absolutely true, and of course it's a great bit of praise for 4:10. But there is there's a serious point, and there's a reason why I take the court to this at the outset of my submissions, because Dr. Mann is entirely correct to opine that this is an area of confusion, and in the context of a doctrine that is said to oust rights, to seek redress against the executive before its own courts for breaches of fundamental rights. This court should search and locate clarity, and I start my submissions by saying this is a case in which the court needs to go back to first principles in order to ask itself, does the common law preclude claims such as this, and if so, why must it? What's the basis for it, and what's the justification for it? Now, my Lord's Lady, I'm going to turn, if I may, to the primary case, which I'm going to split in again two parts. I'm going to look, to begin with, at the narrow Act of State doctrine, and in particular, the three cases cited by Lord Wilberforce, Karen Fracas, Lutheran Sagor, and Princess Olga, and identify them, not least through how they've been treated by courts subsequently, as cases that can only properly be understood as cases about conflict of laws, in particular in relation to the expropriation of property, and seek to explain why they cannot be relied upon by the appellants as a basis for a more extravagant principle precluding the courts from looking at any acts of foreign governments. First part of my primary submission. What I'm then going to do is I'm going to turn to the second limb of Buttes, the non-justiciability limb, and seek to demonstrate that what Buttes decided was in fact a narrow doctrine of non-justiciability. By reference to all the cases that Lord Wilberforce looked at, it's a narrow doctrine that falls comfortably into the Shergill analysis. And then I'm going to seek to explain why this case, in common with very many cases that our courts regularly have to adjudicate upon, but why this case falls comfortably within the constitutional competence of the courts as applying the Shergill test. Having done that, I'm then going to turn briefly on the alternative case, on the Belhaj notion of act of state doctrine, to explain why in our submissions the territorial exception has to apply for it to make any sense, and there is no requirement for there to be proven facts in respect of the fundamental rights, human rights exception. So that's, with permission of the court, is where I'm intending to go tomorrow. I can commence on that now if it will be of assistance, or leave it for tomorrow.
How are we doing in terms of time generally?
My Lord, I am going to finish tomorrow afternoon, but in time for certainly the interveners to get to their feet.
Right. And I think Ms. Kaufman indicated she's coming back briefly as well.
Yes, I think we should incorporate that. I think that's going to be very brief.
Right. Well, if we're doing all right, then I think we've had a long day. Thank you very much indeed. You've given us much to digest overnight. We will adjourn now and resume again at 10:15 tomorrow. I should tell you now, in case I forget tomorrow morning, that there will be 2 minutes silence when we'll all stand at 11 o'clock, and it'll be announced over the loudspeaker tomorrow morning. Thank you very much. Court's now adjourned.